Okay, my dear friends, I would start with the session on preliminary duties and retroactive measures. And I would kindly ask our South Africa friends to start and to moderate it.
Welcome back, everyone. We're looking at now the challenges in applying preliminary and or retroactive trade remedy measures in BRICS. And with regard to preliminary determinations, we know that in terms of the procedures that the various authorities follow differ, and because of the way we interpret the agreement. And maybe just to kick off the discussions, in the case of South Africa, we do make preliminary determinations as a matter of course in all investigations that are conducted, and a preliminary report issued following an initiation of an investigation and following proper procedures for initiating an investigation. And with that, after initiation, interested parties would be furnished with questionnaires to complete and verifications conducted if properly documented submissions have been received and a preliminary determination made. As indicated in the morning, the Commission is the one that makes the preliminary determination.
This is not the... Sorry. Who has the control?
The Commission is the one that makes the preliminary determination, and if a preliminary determination is made and positive and therefore provisional duties imposed, the duties will be imposed and the report is made to interested parties immediately after the publication of the level of duties, and comments are invited, following which the comments would then be analyzed and before the Commission makes a final determination. Maybe I'll stop there and request Brazil. Thank you.
Thank you, Zuleika. Good afternoon to everyone. In the case of Brazil, all preliminary determinations are mandatory under our new law, and as a general rule, we shall publish preliminary determination within a period of 120 days from the date of the initiation, but not less than 60 days from this date. And if a preliminary determination is negative, we may terminate the investigation, but if it's a negative determination on dumping and we hadn't visited the exporter, we'll continue the investigation until our final determination is issued. We do not recommend provisional duties imposition in all preliminary determinations, and even when the COM recommends, not necessarily CAMEX, which the body responsible for applying the duty will apply. In this case, we need to satisfy 3 conditions to recommend and to apply a provisional measure, which is transparency and due process, affirmative finding of injurious dumping, and CAMEX needs to deem the measures appropriate and necessary to prevent injury during the course of the investigation. The main challenge that we face in Brazil is that as we have this short period of 120 days to issue a preliminary determination, sometimes this is a very tight period, especially because we give the exporters 70 days with the extension of the deadline, of the original deadline, to submit replies for the questionnaire. And then we need to analyze the questionnaire, and normally we send out deficiency letters, and at the time that we issue preliminary determination, normally we hadn't verified all the information submitted, and not necessarily we include all information submitted in the preliminary determination. And this is a big challenge for us in Brazil. Apart from that, we normally apply a provisional duty that is lower than the dumping margin. And as we do not apply an injury margin at this stage, normally this duty will be also lower than the injury margin, and which is not sufficient to counterbalance the injury domestic industry is suffering. And another issue that may face is that if the final duty is lower than the provisional duty, we need to reimburse and refund the importers. With regard to the retroactive levy and collection of the anti-dumping duties, we have detailed rules in our new legislation, but we don't have much practice on that. We can apply measures retroactively up to 90 days from the date of the imposition of the provisional measure. And we consider that for that purpose, the date of shipping in the country of export, according to the bill of landing date. We can only apply measures retroactively if 3 conditions are satisfied. We need to have a final positive determination of material injury. Besides, we need to have a history of injurious dumping. And finally, we have to have massive imports. Thank you. We have to have a massive imports in a short time of period. And the main challenge the authority faces in Brazil is that, as I mentioned, we don't have much experience on that, and neither the anti-dumping agreement nor the dispute settlement jurisprudence has defined what massive import means or what a short time period could represent. And apart from that, in Brazil, this is a very sensitive issue, and the CON will only apply if requested and if the circumstances are warranted. We had one problem once in Brazil when at the preliminary stage, we did not find dumping for a specific exporter, and in our final determination, we had affirmative finding of injurious dumping, massive imports in a short period of time, and history of dumping. And in this case, as we didn't issue the provisional measure, we could not apply the measure retroactively for this specific exporter. So we also think that this kind of situation is a bit tricky for us. That's all. Thank you very much.
Thank you, Brazil. We can take any questions if we have for Luis. Over to the ECC then.
Thank you. And can I have the switch? Thank you. I'll try to be quick on the Eurasian Union experience in preliminary measures and really short on retroactivity issue. So as a general rule, we apply provisional measures in the trade remedies investigations just before the end of such investigation. and the decision-making process for application of provisional measures pretty much the same as with final ones. We prepare a provisional report with the proposal and imposition of provisional measure, which then goes to the college for the adoption. And as a rule, we have these reports prepared in case of safeguards investigations within 6 months from the beginning of the investigation, and in case of anti-dumping or countervailing investigations, we try to follow the 7-month rule. Upon the decision, we issue a notice which we distribute to all the participants to the investigations. And well, as the legislation says, in our case, preliminary determinations are not mandatory. We also, as all other BRICS countries, have to get evidence that, for example, in case of anti-dumping investigation, there is evidence of dumping, material injury, and causal link. And in this sense, anti-dumping investigations and countervailing duty investigations warrants additional months to consider, because we do not base our preliminary conclusions on the applications data on dumping or subsidy. So we try to get questionnaire responses to go through the verification process and try to get the evidence on dumping from the exporters' detailed responses. Same goes with the domestic industry. Also, reports for preliminary measures are made on the basis of the questionnaire responses by the domestic industry. The duration of the provisional measures also differ. For safeguards, provisional safeguards duty, it's not more than 200 days, and the form of the measure is only duty, special safeguard duty. We cannot apply, according to the WTO rules, any quota restrictions as provisional measures. In case of anti-dumping and countervailing duties, the rules are the same. The provisional measures can be applied no sooner than 60 calendar days from the initiation of the investigation. And the duration of provisional duty shall not exceed 4 months period, which can be extended upon request by an exporter to 6 months. And with these terms, we have a limitation on the whole investigation time limits. If we impose provisional measures, we have to finish the investigations before the provisional measures are expired. As regards the level of the provisional measures, we also have the provision which warrants that it won't be greater than the margin of dumping or equal to the amount of provisionally calculated subsidies. If as a result of the investigations we come to the negative final determination or non-application of final measures, then importers receive refund of the provisional duty paid in full. In case where final duty is less than provisional duty, then the importer will get a refund in the amount exceeding what he paid. And in case where final duty exceeds provisional duty, we just give back difference. So the difference shall not be collected. In terms of practice, to the date, we've only had 2 cases where we used provisional measures. One of them was safeguards on grain harvesters. and the other one was anti-dumping duty on imports on enamel baths of cast iron from China. So this is everything I have on the preliminary measures. So to conclude that, I should say that we just try to follow the general practice among the members, and I think the rules, the WTO rules here are quite strict and clear. That I cannot say regarding retroactivity, because it's kind of a new piece of legislation for the Eurasian Economic Union and for its member states. But it almost by word follows WTO language. So in order to have retroactive measures, final measure to be applied retroactively, we need a final determination on dumping. And there are three conditions, additional conditions to that. So there is a history of dumping, or importer was aware that the exporter practiced dumping, the injuries caused by massive imports, and the importers have been given an opportunity to comment. For CVD cases, there are two conditions. First one is that the injury is caused by massive imports in a relatively short period of a product benefiting from some subsidy. And B, it is necessary in order to prevent the recurrence of such injury to impose a countervailing duty. In terms of the procedures, we follow the general procedure. We publish, upon the decision, we publish a notice on possible retroactive application on AD or CVD. We don't have special procedures of registration of import or cash deposit, suspension of liquidation since the notice publication. And if as a result of investigation we make an affirmative final determination and we determine that there is the existence of all the conditions specified previously, so this is the case when the final duty can be collected retroactively. We also have the same rules for non-application of the duty on a retroactive basis. So it won't be applied on products which were entered into consumption more than 90 days prior to the date of application of provisional measure, and before the publication of the notice, and before the date of the initiation of the investigation. And as the final slide, we have, as I said, more challenges than practice to the date. So as I said, it's a new provision which entered into force just on January 4th, 2015. We haven't had any cases where we used it yet. We also looking forward to build up a practice on defining what is massive imports or relatively short period of time. Definition should be treated like. And also another challenge would be to see what kind of evidence can be provided in order to prove that there was history of dumping, on that there was an awareness of the importer that exporter employed dumping practices. So that's it for the Eurasian Economic Union. Thank you.
Thank you very much. I think by the nature of the forum that we are having, for us to share our challenges and to learn from each other. I would hand over to China.
Okay. I would briefly introduce Chinese practice. The preliminary determinations are obligatory under Chinese trade remedy system. In terms of retroactive trade remedy measures, according to the Article 44 of Anti-Dumping Regulations of China, when the following two circumstances exist simultaneously, an anti-dumping duty may be retroactively levied on products imported not more than 90 days prior to the date of application of provisional anti-dumping measures, except the products imported before the initiation of the investigation. First, there is a dumping history of the dumped imports causing injury to the domestic industry, or the importer of the dumped imports was or should have been aware that the exporters practiced dumping and that such dumping would cause injury to the domestic industry. And number two, the dumped imports were massively imported in a short period of time and were likely to seriously undermine the remedial effect of the definitive anti-dumping duty to be applied. The Ministry of Commerce may, after initiating an investigation, take such measures as import registration of the import concerned as may be necessary in order for a retroactive collection of an anti-dumping duty if it has sufficient evidence to prove the simultaneous existence of the two circumstances I just mentioned. Thank you.
Oh, okay. I just want to use this opportunity to clarify some practice for BRICS countries for the preliminary determination. According to the introduction, can I get the conclusion is that China, Brazil, South Africa, EEC has the mandatory preliminary determination, but India has not a mandatory determination. That's right?
Yeah.
I just want to clarify this. Yeah. You are mandatory and EEC has our practice is mandatory by law. And India, like the European Union, yeah. Sometimes you have a military preliminary. No? Never. Okay. But the EU is sometimes EU issues the preliminary determination, but some case they will not have the preliminary determination. Depends on the authorities' discretion on case by case.
In fact, under the Indian law, the preliminary finding is not mandatory. It depends on case-to-case basis how quickly the domestic industry is requiring the interim measures, depending on the gravity of the situation, the magnitude of injury and dumping to the domestic industry. So therefore, in every case, we don't issue preliminary finding, but wherever we find is necessary, we do give preliminary finding.
We do it in about 10% of the cases. Only 10%.
In fact, if I'm to clarify, to give the system of the Indian law in preliminary finding, the preliminary finding is basically interim in nature. Under the Indian anti-dumping law, preliminary finding is not mandatory. It gets decided on case-to-case basis, on the basis of application from the domestic industry and the prima facie determination of dumping, injury and causal link. And if authority finds that the preliminary finding is required and the provisional measures are required to be recommended and imposed, then the preliminary finding is given. Under the anti-dumping law of India, there is no time limit prescribed within how many days of the date of initiation the preliminary finding can be given by the designated authority. But under the law, there is a provision that the provisional measures cannot be imposed at least prior to 60 days of the date of initiation of the anti-dumping investigation. Now, under the Indian law, since the Indian law believes, like, relies upon the lesser duty rule, even the preliminary finding is subject to the lesser duty rule as well. The dumping margin, injury margin, whichever is less, is determined on the basis of prima facie determination of the data. Unless of data, the duty is recommended. And the preliminary finding is almost is a replica of final finding, excepting the fact that it's preliminary in nature. All the aspects which are supposed to be examined in the final finding, as per anti-dumping investigation is concerned, all the aspects are examined, but on the basis of prima facie data. In most of the cases, the data of domestic industry gets verified before giving the preliminary finding, but the data of the exporters are verified mostly after the preliminary finding. The preliminary finding is basically the duty which gets imposed on the basis of the preliminary recommendation of the authority, as per the rule, is valid for 6 months, but it can be extended for 9 months depending on if the affected exporters, they make a request, specific request, that the preliminary duty may be extended, but that can be extended only up to 9 months. Thereafter, the duty cannot be extended. And whenever the final finding is issued and the final duty, the definitive duty is imposed by the central government, the duty is effective from the date of the imposition of the provisional duty. That is the date of effectivity of the final duty. And if the final duty recommended is imposed is less than the provisional duty recommended and imposed by the government, then there is a provision for refunding the differential. But in case the definitive duty, as per the final finding, is more than the provisional duty, then the differential is not collected. So that is the rule prevailing in India. And this is as far as the preliminary finding is concerned in India. Thank you.
Can you repeat that?
In case of no preliminary determination, there will not have the provisional measures. Yeah, until you have make the final determination. Okay.
In those cases where the domestic industry is is injured but doesn't require the immediate interim relief, or there are few complicated cases where a lot of data requires to be collected and analyzed. In such cases, the preliminary finding is not given, the final finding is given, and thereafter the definitive duty is straightway imposed. But in such cases, the duty will be effective from the date of notification.
Thank you very much. I take it there are no further questions. Maybe wrap up this session and move over to the next session of conduct of verifications.
Eliza, your turn.
Hello, everyone, again. Although verification visits are not mandatory under the anti-dumping agreement or the other trade remedies agreements, I believe that this is the standard practice among the BRICS countries and other countries as well. We normally go on spot at the premises of the exporter to verify data submitted. In theory, verification visits attempts to verify completeness, adequacy, and accuracy of the information provided by the parties. However, when it comes to practice, things go a little bit more difficult than that. So I think that who has gone already to a verification visit knows that it's quite complicated sometimes for a company and for the investigators to find balance between the information the experts and investigators require and in the format they require and how the company can provide. Sometimes it's hard for the company understand the way the authority thinks because it's not the standard way the company operates in their current day. So I'm looking forward to hear to my colleagues from South Africa and China on their experiences on verification visits. So I'll hand over to South Africa.
Good afternoon, ladies and gentlemen. The legal basis for the Commission verification in South Africa is found in the anti-dumping regulations as well as the countervailing regulations. The Commission normally conducts verification on producers, on cooperating importers, on exporters, as well as foreign producers. The pre-initiation verification visit to domestic industry. The Commission conducts verification visits to the applicant, the domestic industry, in order to satisfy itself to the adequacy and accuracy of the information submitted in the application. The verification is conducted normally after a properly documented application by the applicant to determine whether the applicant has provided a prima facie case to make a case of dumping, injury, and causal link, and in order to continue to initiate the investigation. For the SACU industry, the Commission will normally verify the like product or the SACU-like product. For this process, the commission verification process starts with a factory visit where the official observe and are familiarized with the production process of the SACU product, including the source and input of the main raw materials used to manufacture the product. From there, the commission officials will move on to verify the dumping information that is contained in the application. The officials will interrogate, just a moment. The official will interrogate the basis of the allegation of dumping, that is the source of the normal value, as well as the export price, as well as any adjustment that may have been claimed, in the calculation. The commission will then, or the officials will then continue to verify the information that is submitted in justification of the allegation of injury. In determining injury to the SACU industry, the Commission normally follows a trend analysis over a period of 3 years. Therefore, applicants in their application are required to submit 3 years information on each of the injury indicators. Article 3 of the anti-dumping agreement provides that the determination of injury be based on positive evidence and involve an objective examination of the volume of the dumped import, as well as the consequent impact of this import on the domestic producers of such products. Therefore, when verifying injury information, the officials of the Commission will start by verifying the price information submitted by the applicant in support of the alleged negative price effect, that is, the price undercutting, the price depression, and the price suppression. The second requirement or obligation under Article 3 is the examination of the impact of the dumped import on the domestic industry. In fulfilling this requirement, the officials of the Commission will verify all the information submitted by the applicant in support of the allegation of negative impact of the import on the domestic industry. So therefore, the Commission will verify, the 3 years information on sales, on profit, output, market share, productivity, return on investment, cash flow, inventories, employment, wages, growth, and the ability of the industry to raise capital. That is done, unlike with our Russian colleagues, that is done well before the investigation is initiated. Then the Commission will also go verify or have a discussion with the industry on any information that is submitted on causal link. I'm now going to deal with the information that the officials of the Commission check at the exporter premises. At the initiation of an investigation, the Commission sends out questionnaires to known exporters, requesting them to provide relevant information in the prescribed format. The information that is verified at the exporter's premises or the foreign producer can be divided into 3 broad categories. That is, your general information that will, ask for the name of the company, the address, the pricing information that will include all relevant information relating to domestic sales, export sales, financial information, as well as costing information. The first step of initiation at the premises of the exporter is similar to the one that the Commission conducts at the premises of the applicant, which is a walkabout in the factory, to familiarize the officials with the production process of the product, and also to observe if there are any differences between the product that is sold in the domestic market as well as the product that is exported to SACU. After the walkabout, then the officials will move on to do a verification of domestic sales. This is done by, checking all the transactions in the domestic market. The officials will then also verify the sales to foreign market, which is a backup method in case, the domestic sales do not meet the requirement. The cost of production will also be verified. The cost of production of the exporter will also be verified. The constructed export price in case of related parties. In cases where the manufacturer and the exporter is related to the importer, the Commission normally constructs an export price based on the price to the first independent buyer in the SACU market, less the cost incurred between the exporter and such independent buyer. The last item on the presentation is the threshold for a successful or a failed verification. The Anti-Dumping Regulation 18.4 provides, among others, that where a party fails to supply relevant substantiating evidence required during a verification and also fails to explain any calculation contained in its submission or otherwise fails to cooperate during the investigation process, the Commission may terminate the verification proceeding, and the Commission may disregard any or all of the information submitted by the party in question. I thank you.
So I'll give the floor to China.
My presentation will focus on the on-spot verification to exporters in the territory of other members. I have a verification experience of more than 10 years, and I have verified the exporters or producers in the United States, Germany, Netherlands, the United Kingdom, Japan, Korea, and Singapore, etc. Personally, I like on-spot verification because of two reasons. First reason, on-spot verification means working abroad for a short period. During this period, you could feel different cultures of different foreign companies. And second reason, on-spot verification is quite challenging. You have to organize your work very well in order for you to finish it timely according to your plan. Today, I'm happy to share my experience with all of you. On-spot verification is not an obligation of the investigating authority. Article 6.7 of Anti-Dumping Agreement of WTO lays out the basic framework for the conduct of exporters verification, while Annex 1 of Anti-Dumping Agreement contains more detailed procedures. Authorities are not obliged to verify the information provided by the exporters. The word may used in Article 6.7 of ADA makes clear that on-spot verification in the territory of other members are permitted but not required. However, on-spot verification is necessary. Why? On-spot verification is the verification to questionnaire response and also other information submitted by exporters. Questionnaire response is the basic foundation to decide dumping and the dumping margin. If exporters know that the questionnaire response they submit will not be verified, it is quite possible that they will cheat in their questionnaire response. So, on-spot verification is an important mechanism for investigating authority to carry out the investigation. In Chinese practice, in most cases, TRB will carry out on-spot verification. In Chinese practice, on-spot verification is normally carried out after preliminary determination and may also be done before the preliminary determination. In special cases, before on-spot verification, TRB shall obtain the explicit agreement from the exporters and the producers concerned. TRB will not carry out on-spot verification if the government of countries where the exporters and the producers concerned are located objects to the visit. The purpose of on-spot verification is to verify the completeness, genuineness, and accuracy of the information provided by exporters and the producers concerned. As I mentioned earlier, before on-spot verification, TRB shall obtain explicit agreement from the exporters and the producers concerned. Prior to the on-spot verification, TRB shall notify in advance the exporters and producers in question of the concrete timetable for the verification. The verifying team shall, prior to the on-spot verification, notify the exporters and the producers in question of the general nature of the information to be verified and of any further information which needs to be collected. The verifying team may where it considers necessary, issue a detailed list of questions for the verification to the exporters and the producers prior to the verification. TRB will normally assign a team of at least 2 case handlers to conduct the on-spot verification. On-spot verification will normally take 2 to 3 days for each exporter or producer. Anti-dumping investigation would become totally unmanageable if investigating authorities were required to actually verify the accuracy of all information relied on. So TRB will select and verify some samples out of all the transactions when carrying out verification. After the verification, TRB shall, within a reasonable period, disclose the result of the verification to the exporters and the producers, subject to the verification. In terms of the principles, full cooperation of the exporting producer is necessary. The exporters and the producers, subject to the verification, shall cooperate actively with the verifying team during the verification and make the staff originally responsible for the preparation of the response to the questionnaire and other staff concerned available and able to explain any questions raised by the verifying team. And the second principle, new information is not accepted during the verification. Never forget the purpose of the verification is to verify questionnaire response. The third principle, minor correction is allowed before the verification starts. This is because findings and conclusions will almost be based on the written documentation provided by the interested parties. Such evidence tends to be voluminous and must be compiled within the relatively short time period of generally about 30 days. So clerical errors may therefore occur. And the fourth principle, misleading and manipulated data will lead to negative conclusion. TRB may make determination of dumping and dumping margin on the basis of facts available if serious problems are discovered during the verification with respect to the genuineness, accuracy, and completeness of the information and materials provided by the exporter and the producer in question, or there exists obvious fraud or concealment conducted by the exporters and producers in question. Thank you.
Thank you, China. I'll take questions.
Wait. Yeah, I just want to make discussion among our members. I just want to clarify in your practice before not before, maybe in the verification, on-spot verification, do you, if the exporters provide new evidence or new figures, informations, do you accept that new information, evidence? Normally, our practice is there's no provision in our law and regulations, even rules, ministerial rules, But in our practice, normally we will, through the questionnaire, to tell the exporters that you must provide all the information or evidence before verification. For example, 1 week before or 2 weeks before, we will inform the export by through the additional questionnaires or notice to the export. But always there's some export would like to make some correction to their to the questionnaires they have submitted to us before. Such correction will result in the change of dumping margin, is significant correction, not just narrow, correction. So, and also some export will make such a new information or new evidence or new figures during the verification. So, according to your practice, normally you will accept those information or evidence after you have informed of the exporters the deadline of the provision of the evidence or during the verification. So I just want to know your practice. Okay.
As far as Indian practice is concerned, the exporters from the subject countries are given 40 days time from the date of initiation in case of not known exporters, and in case of known exporters, 40 days time from the date of circulation of the initiation notification. That almost comes to almost 60 days time. Almost 2 months time is given to exporters to file the exporters question and response. Now, after getting 60 days time, if once the exporters question responses are filed, then the exporters are given opportunity to provide their consent for verification along with the government of the exporting country. Now, after writing such letter, more or less 2 weeks time is given, 1 month's time is given to the exporters to prepare the data. Now, during the verification, if the exporters on their own, they bring to the notice of the verifying authority that there are minor corrections, there are typographic errors, there are certain corrections which are required in the information, then such minor corrections, typographic corrections are accepted and modified appendices are accepted. But if there is drastic correction, not correction, the drastic change in the data, then it is not justified how to accept such drastically changed data during the verification. It is not accepted.
First of all, as in any other jurisdiction, I think, there is a time limit for supplying the information. If this information is supplied, filed with us later than this deadline, we have a right not to take it into account and use the best information available. But in most cases, the data from the exporter is the best information available. What I should say is that the decision whether to take this information for the calculations, for example, it depends on the nature of the changes. I think in almost every case when we verify exporters, there could be found something, transport expenses, LGA, anything else, minor corrections to the provided data could be found almost in any case. What if we find that the complete data for the costs, for example, is to be refiled. I think that would not be accepted. We have not faced such cases, but I do believe that we would not allow the exporter to do that. We just would even probably leave the verification visit. But corrections are allowed, and we understand that almost no company in the world is. It's just not possible to complete the questionnaire and not to allow any minor mistake. Anyway, people are people all over the world, and they make mistakes. They put 2 instead of 1 while printing it in, and but that's the reason. It depends on the nature. What the exporter is trying to do. If it's a completely new picture of the world, okay, it would be non-cooperating company, most probably. If it's maybe it's a question more to our Brazilian friends when they told us some days that if they find one new invoice, it's over. I don't think that we are that strict.
Yes, this would be my next question about the non-reported sales, but on your question, Madame Zo, in Brazil, during the on-spot verification, normally we do not take into account new information provided because we consider that under our law, we give a very large period for the exporters and also for the domestic industry to provide information, and therefore after that period no new information can be provided, but they can comment and provide more details about the information they had already submitted. So as long as the information is not a minor correction and it's submitted during the verification visit, we will not accept it.
Yeah, I think our practice probably the same as everyone else's. A minor correction just sometimes is not minor. You know, sometimes they say, oh, but it's just something small, but it has a huge effect. What I do think is, I think it's important for investigators and for the authorities to know the information before they decide that they want to verify. In a lot of instances, you can see that information is incorrect. When you go through it, you compare it with financial statements, or you compare it with information given in response to one particular question is maybe different when it's the same. It's still sales or still production or still some cost, but it's given as a different value in different answers to a question. And to make the exporters aware of that in the deficiency process. It becomes very difficult because the investigators go there and they don't have the authority to say yes or no. If an exporter presents information, even though you are telling him, remember, this is new, we will not take it into account, you open yourself up to some controversy. On the one hand, you don't want investigators to be there and in a position to make decisions because it places them in a very difficult position. On the other hand, you also don't want to allow exporters that leeway to submit complete new responses. So it's something that we struggle with on an ongoing basis. We try and make exporters aware that we won't accept new information. And we try and make the investigators well prepared through the deficiency process to make sure that if you do go on verification, that there can't be any real surprises, in terms of mistakes that would make a difference. But we don't accept new information. I think it would be unfair. It's unfair towards you know, for the whole process. It's unfair towards other participating parties and your own industry.
Any other question?
Perhaps if I can just comment, because I think what you need to look at is the balance in the agreement, because the exporter or the importer, they have specific rights. Now, the domestic industry also has certain rights, so how do you balance it? Now, it can be that I'm a very clever exporter, and I don't submit information when I'm supposed to submit it. I hold back key information, or I give you wrong information, and then I submit to you the right information or additional information at a critical time. And sometimes it is not possible to go back and to verify the information. And then clearly the agreement, the way how the agreement has been interpreted, would not protect the exporter trying to strategize and to play the system. On the other hand, if it's a bona fide mistake, and if to consider it will not unduly delay the process, then you're going to be difficult to justify why you did not take it in consideration, although you have deadlines. You have to be careful, and then it's also a question that if you miss a deadline, how that is dealt with in your own administrative domestic law compared to WTO jurisprudence. So to cut a long story short, what I would advise investigating authorities to do is to play it very, very safe. And if you need to reject the invoice or some information, to explain why you couldn't take it into account. That it would have caused an undue delay in the process, or because of domestic administrative law requirements, you could not take it into account because of the rights of other parties. And if you take it into account, you'll have to give the other side opportunity to comment on it. So it's just to play it safe. Now, it hasn't been that much, as I can recall, that much issue in dispute settlement, but I can see it coming. You're not going to declare a dispute on the basis of only this, but it might be dragged into a dispute. I would play it safe and make sure that I've covered all the bases.
Thank you. Any other question?
I would request the member countries, what is the duration of exporters verification? Now, as far as India is concerned, when we go for verifying the data of the exporters, then we complete the verification in maximum 2 days' time for each producer exporter. I want to know about other countries, how do they do the verification?
In Brazil?
Like, I request all of you to let me know, how many, each exporter, how many days? 1 day, 2 days, 3 days, what is the limit?
Okay, in Brazil we take 5 days in each exporter, and we verify sales and cost. Except for China, that will take 2 days because we verify only export price.
In our practice, it's usually 2 or 3 days for exporter, depending on the complexity of the case, number of companies, number of channels of sales, etc. But usually it's 2-3 days plus for each producer, I would say, because we usually also verify related companies located on the territory of the Eurasian Economic Union, which would add to that another 1-2 days.
If the producer and exporter separate, then at least 1 day each.
I would say that 2-3 days for each producer and 1 day for exporter, for trader.
We also spend about 2 days at the premises of the exporter.
Thank you.
I'll take any other question.
I have a couple, probably to our Chinese colleagues. The first one is about the timing of verification. Do you conduct it before the provisional measures, decision on the provisional measures necessarily, or you can delay it just after the provisional measures are imposed? And the second question, you told us about the disclosure you make after the verification visit to exporters and producers, but can they see non-confidential versions of these verification visit reports as a part of non-confidential file of the case? Thank you.
Regarding your first question, in most cases, China will conduct the on-the-spot verification after the preliminary determination. But I remember in one case, in two cases, we also verified companies before the preliminary determination. For your second question,
to China, to who? I don't know.
We mentioned China's presentation, saying that there is a disclosure report after you made the verification with it, and my question was whether it is made available to other participants to the investigation in non-confidential format as a part of the investigation file.
Okay, thank you. In Chinese practice, we will disclose the results of the verification to the exporter and the producers concerned. But if other interest parties request, we will also disclose the non-confidential version to them. Thank you.
The case about maybe 99 or 98 will conduct the verification after preliminary. Only 2 cases that's very special. Without verification, we cannot make the decision for the preliminary determination. So the transaction is too complicated. So if we just based on the questionnaire submitted by the exporters, we cannot make such decisions. So only in that 2 cases we conduct the verification before the preliminary. We just want to make our preliminary more reasonable or more precisely. We don't want to, after the preliminary determination, and then there are huge changes in the final determination, you know. So just in very special cases, depends on the business transactions, so it's complicated, and we cannot make decisions, only rely on the questionnaires. So.
Thank you. Any other question? Okay, so I think we can move to the next session.
Thank you, Leila. So in the next session is supposed to be about judicial and administrative reviews of trade remedies in China. Could you please start?
Good afternoon, everyone. It is my great pleasure to serve as the moderator for the last session for today, the administrative and judicial review of trade remedies in BRICS countries. As we all know, Article 13 of the Anti-Dumping Agreement and Article 23 of the SCM Agreement require WTO members to maintain judicial, arbitral, or administrative tribunals or procedures for the purpose of the prompt review of administrative actions relating to final determinations and reviews of anti-dumping or countervailing measures. The two agreements also require such tribunals or procedures to be independent of the authorities responsible for the determination or review in question. However, similar provisions cannot be found in the Safeguard Agreement. We do believe that the administrative and judicial review plays a very important role in ensuring the rights of interested parties in anti-dumping and countervailing procedures. However, in practice, the administrative review and judicial review systems vary a great deal among different WTO members due to their different legal and political framework of those countries or regions. In this session, we will share information on the operation of the administrative and judicial review systems of BRICS countries, and I believe everybody will have great interest in this topic. I think I can still recall that the day before yesterday, our South African friends said something about their domestic enterprises will sue them for anything. So today we can hear more about the practices of the BRICS countries. And now let's first welcome India to present their system.
Thank you. I will just briefly dwell upon the administrative review and then come to the judicial review. In the administrative review, as we all know, there is a midterm review and a sunset review. The midterm review in India, we can initiate either on our own, that is the DGAD himself can do it, or it can be done upon a request of the interested party. But we do not accept a midterm review application at least 12 months before an order of imposition of anti-dumping duty has been done. So if on the 1st of January of a particular year, we have imposed the duty, then the earliest we take a midterm review is after 12 months. As regards the sunset review, it is terminated 5 years from its imposition, but if there is a sunset review application filed by the domestic industry within a reasonable period of time prior to the expiry of the duty, then the duty remains in force pending review of the outcome of the sunset review. Normally, if we have initiated the case of sunset review, then automatically the duty gets extended by 1 year, during which time we have to complete the investigation. Now, as regards the judicial review, we have a separate court called the Customs, Excise and Service Tax Appellate Tribunal, which has 3 members. All 3 are judicial members sometimes, or twice, or 2 of them are judicial members, and 1 of the members is a customs official. This particular tribunal decides, apart from anti-dumping cases, cases of customs, excise and service tax also. Now, the direct appeal from the anti-dumping designated authority lies before this tribunal, but only for cases of final findings. No preliminary findings of the authority can be agitated before this tribunal. The appeal against the order of the notification has to be filed before the tribunal within 90 days. If it is beyond 90 days, then it is the discretion of the tribunal to accept such a particular appeal or reject it. As of now, just before coming, we had tabulated the data, and about 90 cases are pending in the Central Tribunal. The second appeal forum is the High Court, but you can't agitate matters of merit in the High Court. Only it has a writ jurisdiction. So if you say that opportunity of being heard was not given or some principle of natural justice was not followed, then the High Court entertains such appeals. And there are 29 cases pending in various high courts of the country. We have a high court in each state and we have 29 states. So roughly one case per high court is pending for adjudication. The final authority in any case of appeal is the Supreme Court of India. If a particular party is agitated against the tribunal's order, then it can go to the Supreme Court. Supreme Court also hears all appeals against the High Court orders also. And there are 19 cases pending in the Supreme Court of India. Thank you.
Thank you, India. I think maybe if we have any question that we feel we have to ask India right now, or you can, or we can just go on with the other presentations and save all the questions to the last part. So please, EEC will be the next one.
The judicial review within the Eurasian Economic Union is done by the Court of the Union, which is located in Minsk, and there are some legal provisions which are regulating these issues related to the review of the measures. The relevant provisions could be found in the Annex 8 to the treaty, which identifies some of the requirements to the legal review. The trade remedies could be challenged to the Court of the Union in accordance with the statute of the court and the regulation of the court. And the statute of the court identifies that the court could review the consistency of the Commission decision to the provisions of the treaty, and if such a decision or its separate provisions leads to the violation of rights and interests of economic entities, the court could issue a recommendation to bring the measure into compliance, and the Commission has to open a review to change the measure, which should be initiated on its ex officio and to be completed in 9 months. So the Commission has 9 months to bring the measure into the compliance if the court identifies that there were certain breaches of the legislation. The measure could be challenged by any economic entity which has economic interests related to the application of the measure, but in most cases, in our previous practice, all the participants to the investigations were interested in such activity, but however, we should say that the importers also pay quite a lot of attention to the measures and could be interested into the court procedure. One of the specifics of our procedure is the involvement of so-called group of experts in the procedure. So the statute for the court and the protocol identifies that there is a group of experts which consists of experts from member countries, those experts have to be competent and professional and well-known experts in the specifics of the particular case, in particular area. In case of trade remedies, those should be the experts in trade remedies. And experts could be not only the citizens of the countries of members of the union, but also could be some experts from other countries, so well-known international experts. The judgment of the court could be appealed with the appeal commission of the court. What could be also mentioned is that the regulation of the court identifies the Article 45 of it identifies the standard of review for the review of trade remedies, and to a certain extent it's based on the standard of review in dispute settlement bodies, WTO. And with respect to the procedure, I should mention that the Court of the Union is not the specialized court for the trade remedies. It's the court which is responsible for for judicial review of all the measures, all the decisions of the commissions, including decisions on tariffs, technical regulations, SPS measures, competition, etc. So the trade remedy is only part of it. The court could review not only the Commission decision to impose the measure, but also the inactivity of the Commission. So if the Commission not applying the measure or not initiating an investigation or not acting in accordance with the provisions of the treaty, it also could be reviewed by the court. Technically, the procedure could be shown as follows: that there is a mandatory requirement for prejudicial procedure. So an interested party should send to the Commission the complaint, sort of complaint, identifying the elements of the measure which is trying to ask to review, or which are not in compliance with the legislation in the opinion of this interested party, and the Commission has to react to this prejudicial complaint. Only after that the party has a right to file a complaint to the court, and within the court the procedure could take not more than 135 calendar days. And if the decision is appealed and the court issues a recommendation to bring the measure into compliance, the Commission, as I tell, has 9 months to do that. A bit more words about this group of experts. This group is sort of its purpose is to give recommendations to the court on highly technical, especially on the highly technical issues related to the case. Everybody understands, and we understand it from our previous experience, that the judges are not experts in trade remedies, and it's not an easy task for them to try to understand whether the dumping calculations, normal value calculations, or the duty calculation was done in accordance with the law. And taking into account that our legislation provides almost for direct application of WTO rules on that. So we've got a treaty on customs union in terms of multinational systems, which is usually called Friday Agreement, which identifies as the obligations of Russia under the WTO have a direct effect on the legislation of the Customs Union and respectively Eurasian Economic Union, and should be applied directly, and any measure which is not in compliance in accordance with the WTO should be changed. Taking this into account, the Court of the Customs Union takes the position, and I think this position would be taken by the current Court of the Eurasian Economic Union, that WTO rules a source of law for this court, and we should mention that it's almost the only source of law in terms of the interpretation, because anyway all the WTO jurisprudence is much more detailed than our protocol, our annex devoted to the trade remedies. So the court looks at the DSB decisions as a source of law for them. So for us, it's also one of the great issues, because when a judge from Russia, Kazakhstan, or Belarus, or Armenia is trying to use the WTO DSB panels and appellate body interpretations, sometimes it's not easy, and this group of experts is supposed to help judges with that. The official role of the group is that they issue a report to the court, and the judges have to react to this in their judgment. So it's not mandatory for the court, but anyway, they should take it into account. As I told, 3 experts are selected for each case from the list, from the roster, which is provided, the candidate to which is provided by the member states. The report of the group of experts is to contain an objective assessment of facts relevant to the case, and the conclusion regarding consistency of the measure with the Treaty of the Eurasian Economic Union. What I should say also is that the regulation of the court identifies certain requirements to the standard of review, and this requirements states that the court's examination of the case is limited to factual basis and the claims indicated in the complaint, so they could not review any other arguments out of the terms of reference of the and their judgment is to be limited to the investigation record. So they could review only the data received by the agency, by the investigating authority within the investigation. So they could not consider any new arguments in the case. And the court examines whether the Commission has fulfilled procedural requirements and properly applied the rule of law, whether the Commission properly used the evidence and established the grounds for adopting the decision, and whether the relevant conclusions of the Commission were justified in accordance with the protocol. And with regards to the implementation of the court's judgment, the legal basis for it is the paragraph 276 of the protocol. The implementation is to take the form of partial review of the measure to address the judgment. The review could not be, is to be concluded within 9 months. And the scope of the review is limited to the judgment of the court. One more, another new requirement to that is that, which is worth to mention, is that the court is, while reviewing the measure, the court could not make the decision of non-compliance even if there was a mistake, for example, but if the mistake was not so significant that if it was not made by the Commission, even if there wouldn't be no mistakes, the decision of the Commission would be the same. So in this case, the court could not make the decision that the measure is not consistent with the protocol. And until now, we had actually 4 or 3.5 cases when we had 3 cases in the court on forged work rolls, on cold-rolled flat steel products with polymer coating and graphite electrodes. Another one was a prejudicial procedure for light commercial vehicles, but the interested parties decided not to go to the court finally. Well, maybe not finally, but right now the procedure is not in the court. Thank you.
Thank you, EEC. So now let's give the floor to South Africa. South Africa, please.
We have talked some about South Africa being part of a customs union, although I don't know whether we have gone into a lot of detail. But listening to Vladimir now, it just reminded me that I should maybe put that into perspective. We are part of the customs union, and our agreement makes quite adequate provision for a tribunal and legal action and disputes and administrative reviews. But because the agreement has not been implemented fully, we also do not have the ability to use those provisions of the agreement. So because ITAC is doing these investigations on behalf of SACU, we are still in a South African company, South African organization, and we operate in terms of South African law, and therefore all reviews are also done by South African courts. And in South Africa, the trade remedies issues are all adjudicated by a general court. It brings a lot of problems for us, as I'm sure most of you would understand. So a lot of the reviews that are brought in the High Court result in referral to the Supreme Court, and some of our issues also to the Constitutional Court. In terms of the International Trade Administration Commission Act, a person affected by any determination or recommendation or decision of ITAC may apply to the High Court for a review. So that also means not just final determinations, but also prelim determinations and any other determination that the Commission makes in the process of an investigation. Also, therefore, decisions on whether to accept information as confidential or not can be taken on review. And then Section 47 of the Act provides for referrals to the Supreme Court of Appeal and the Constitutional Court if you don't agree with the decision that the High Court has made. The issues that can be adjudicated on are quite wide. In South Africa, we have the Promotion of Administrative Justice Act, which provides that any action that is taken against an individual or an organization must be lawful, reasonably, and procedurally fair. So you have a wide discretion of provisions to take the Commission on review in terms of administrative legal action. And people use that quite often. We have learned in the process to be very cautious in the administrative process, and we haven't really been taken on review in terms of procedural issues. But unfortunately, courts can also, although they're not generally supposed to, they also make decisions on merit of cases. So the focus is procedure, but courts also intervene in terms of merits of a case. And in those instances where we don't agree with merit decisions that the courts make, we have to go on appeal to the Supreme Court, and we've also in one instance gone to the Constitutional Court to try and rectify such a decision. What are the consequences? Yeah, well, normally what they would do is they would set aside the decision and refer it back to ITAC to reconsider. But they can also vary the order, make a different administrative order. They can also, although they have never direct the administrator to pay compensation, which fortunately has never happened. There are also provision for declaratory orders. We have used this in instances where a decision is made particular to a specific investigation. Then the Commission has gone back to the High Court and asked for clarity on whether that applies to all cases or just the particular facts of a particular case. They can also direct us to act in a specific manner. There has been cases where the Commission, in its discretion, decided not to initiate a case, where the domestic industry then went to court and asked the court to direct the Commission to initiate such an investigation. It can also prohibit us from acting in a particular manner. It can make orders towards cost, and it can also direct us to make a decision if in instances where the Commission might take too long according to a particular party. In terms of WTO case law, the agreements have not been enacted into South African law, so they are not law in South Africa. But the Constitution provides that when you interpret domestic law, you have to take international agreements into account. So the courts definitely take due regard to decisions, panel decisions that come out, and therefore we also try and apply all the findings of panels in our daily practice to make sure that it is consistent. That is our story.
Thank you, South Africa. And now I will have my colleague, Mr. Lin Hong, to present our own system. Please, Lin Hong.
Good afternoon, everybody. And now I would like to give a brief introduction about judicial review system of China. Article 13 of Anti-Dumping Agreement of WTO is that each member should have in his national legislation should have a provision to have a independent organization or a judicial body to examine the administrative decision regarding the trade remedy. And based on this article, I think the member of WTO set up their own judicial review system. In China, we have we have two sets of laws and regulations regarding the judicial review. First one is a general kind of regulation regarding the administrative action. This includes the Administrative Procedure Law of PRC, and also the Foreign Trade Law of the People's Republic of China has a provision to say that if any party affected by the administrative behavior, they can bring a suit. And also in the anti-dumping regulation of PRC, there also stipulates that the interested party have the right to bring the case to the court. This is particular for the first regulation, the administrative procedure law is not only dealing with the trade remedy case, it's dealing every administrative case. The second part is China has also special rules regarding the judicial review of trade remedy case. That is, in year of 2002, there's a provisions of the Supreme People's Court on several issues concerning the hearing of international trade administrative case. The other one is the rules of the Supreme People's Court on certain issues related to application of law in hearing of anti-dumping administrative case. These two rules is especially for the trade remedy case. For the judicial review, actually China has two different systems. One is within the administrative system. The other is a court system. Through these two different kind of systems, the party can get remedy. These two systems has different characteristics. For the administrative system is we call the administrative reconsideration. It means that if a party is not satisfied with an administrative action, then they can go to a higher level of administration to complain about this, and the high level administrative entity will examine whether the low levels administrative behavior is right or not. And because of the trade remedy behavior is done by central level, so for the trade remedy case, the administrative constitution is also go to the central level. And they have some characters for the administrative constitution. Is free of charge. There's no fees for bringing a case. And the procedure of this administrative reconstitution is a relatively short period of time compared to the court proceedings. For the court proceeding, administrative suit before it's a legal procedure. If the party is not satisfied with the administrative behavior, they go to another different kind of system. It's a court system, not within the administrative system. These two, actually the party can choose either one of these. None of each is the precondition of the other. And the party should be careful that a party can first bring administrative reconsideration. If the party still does not satisfy with the result of this administrative reconsideration, they can still go to the court. But on the other hand, if you first choose to go to the court, then you cannot go to the administrative reconsideration again. What can be challenged in administrative reconsideration is the activity done by the administrative, in trade remedy case, if a determination made by the Ministry of Commerce can be challenged. For example, our final determination can be challenged in administrative reconsideration. And the jurisdiction for the administrative reconsideration for trade remedy case is I just now have mentioned, is the same level, also the central level. So it's should be hearing by the Department of Treaty and Law in the same ministry. Our Bureau of Trade Remedy and Investigation is within the Ministry of Commerce, and the other party, the other Department of Trade and Law, they are responsible for hearing the administrative reconsideration. What's the result of this administrative reconsideration? If the investigating authority does not done wrong, the judgment could be sustain the determination. And if we lose, and then the determination can be revoked. And also our determination can, and also the Department of Treaties can ask us to make a new determination. Basically, this is three kind of a result of administrative reconsideration. For the administrative suit, what can be sued in the administrative suit? Actually, it can be the following activity can be sued. First one is a final determination on dumping margin or injury or extent of injury can be sued. Second one is a decision of whether or not to impose anti-dumping duty, because this decision is made by the Tariff Commission of the Council. So in the administrative reconsideration, if you choose administrative reconsideration, you should go to the State Council to sue the decision, but you can go to the Department of Trade Law to sue the determination by Commerce, because the decision to impose duty is not done by Ministry of Commerce, it's done by Tariff Commission of the Council. Third one is the reimbursement of anti-dumping duty or impose of anti-dumping duty on new exporters. And also the result of the administrative review or the price undertaking can also be sued, and other actionable administrative activity in anti-dumping proceeding. For the administrative suit, the jurisdiction is because for the first instance is the Interim People's Court of China. For the second instance is the Superior Court of China. And after these two instances, it's a final judgment. And normally, the trade remedy case will now go to the Supreme Court of China. And the result of this administrative suit is similar with the reconsideration, is sustain or revoke or ask us to make a new determination. And in practice, we have 5 administrative reconsideration. Among these 5, one was revoked, and we have 1 judicial review case, and in that case, the plaintiff decided to withdraw the case. I think that's all for China. Thank you.
Thank you, Lin Hong. Last but not the least, we will hear about the Brazilian system. Brazil, you have the floor. Thank you.
Thank you. In Brazil, any decision made by the CON or CAMEX can be reviewed in both tracks, the administrative and the judicial one. If a claim is made for administrative review, it has this deadline of 10 days from the date the decision was made, and then it's first submitted to the authority who issued the decision, and the authority may decide to change or maintain. If the authority decides to maintain, it raises the complaint to 2 more levels, and this is the maximum. So all decisions taken by the CON can go to the director or to the Secretariat of Foreign Trade, and the last level would be the minister. If it's a COMEX decision, as this cannot go to the president because COMEX is made of 7 ministers, then the administrative track for reviewing this decision is a request for reconsideration. And in this case, the parts also have the same period of 10 days to submit a request for review. In Brazil, we have a lot of requests for administrative reviews of any decisions, and there is no rule. Sometimes we review and sometimes we reject the claim. As for the judicial review, we have no specialized courts or tribunals. Therefore, all matters related to trade remedies decisions goes to the general courts, and federal judges are responsible. Federal judges who are responsible for administrative, tax, and economic issues are also responsible for deciding about trade remedies issues. They can be single judges. So they can be single judges, federal courts, the higher court of justice, and the last level would be the Supreme Court. The issues that can be adjudicated in judicial reviews in Brazil may vary. If it's a COMEX decision, it can be either the imposition of provisional measures, the form of the imposition of the provisional measure, the definitive measure, or the suspension of a measure for reasons of public interest. And the decisions the COM make that can be challenged includes initiation of investigation, rejection of untimely submissions of questionnaire responses, rejection of a part's untimely undue request for being treated an interested party in the procedure, termination of investigations or review without duty imposition, and rejection of price undertaking offers. Petitions may be filed with the higher court of justice or at the first level of the federal judiciary, depend on the author of the decision. All decisions made by COMEX must be appealed before the higher court of justice, and if it's the COM decision, either the director or the Secretariat of Foreign Trade will be appealed at the first level of the judiciary. So roughly speaking, we could say that there is as such appeals in which the complainant need showing that the illegality of the decision breaks an unquestionable right of the complainant, and these petitions may be filed before the higher court of justice or at the first level of the federal judiciary, depend on the author of the decision. Or it can be also as applied decisions, which require fact-finding and production of evidence, and these are petitions filed with the first level of the judiciary. In Brazil, the courts can review both the merits and procedural aspects of investigations. However, they hardly ever review the merits. That had never happened so far, because they believe the administrative decision should prevail if the merit is being challenged. Judges can and the courts can also issue preliminary injunctions to anticipate the effects of the lawsuit applicable to the case, and these apply to both kinds of appeals. So we have, I just brought some concrete cases, and these are very recent decisions that the COM's decisions denying an interested part who came forward untimely to the investigation This part requested a judicial review to be considered as interested part, and then the judge gave the part the duty, the right to be considering the investigation. Therefore, in the end of the investigation, the court needed to review its decision, then need to consider this part as interested part, and then review its final decision. So when the CON or CAMEX loses the case, it might need to review partially or totally the decision. When there is a preliminary injunction issued by the court, they can only be granted upon upon submission of a guarantee by the importer, and the complainant that's normally importer needs to show the verisimilitude of the legal basis invoked to support his request and the urgency of precaution of the measure. And the final decision is generally based on procedural aspects. And these are other concrete cases, and it's all. Thank you very much.
Thank you, Brazil. I think after hearing all the presentations, we will have the impression that unlike the investigation and determination procedures, which we very much alike each other, the administrative and judicial review systems of BRICS countries appear to have many more differences. I believe that will trigger a lot of questions among us. But first of all, I will take the privilege of being the moderator to ask the first question to our host, Mr. Ilichev. Well, I'm very interested in the group of experts you've mentioned in your presentation. I would like to know who will choose those experts who will decide the composition of the 3 experts for one case, and do the interested parties have any say? Can they make any argument about the members of those 3 experts? And do the group of experts have any roles to play in appeals? Thank you.
Good question. Frankly speaking, I don't remember the procedure which is written there. As I remember, it would be the secretariat of the court. But there is a right to put objections to the particular experts, which the interested parties have. Actually, it's a new procedure which is yet to be. We yet have to go through. It's just the newly adopted one, and it's in effect only from the 1st of January of this year. So we haven't yet any actual experience in that. But we do hope that these groups of experts would help the court also to put some highly specialized expertise in that, and it would be really helpful at this at this stage of development, and taking into account that the court and the judges in our countries don't have a lot of experience in that.
Thank you very much. I think the floor is open for more questions.
I have one question probably to all panelists, because in reality, if you are under anti-dumping or countervailing duties, in reality you have a choice whether to challenge it through national court or try to convince your government to go to DSB. And there are some arguments in favor of both options. For example, arguments to challenge it to national court could be that first it's faster, second one in cheaper, and third one in DSB you can't get any damages. And so I would like to ask you, can you give us any damage statistics related with sort of cases to national courts? So where in your country's real cases when countervailing or anti-dumping measures duties were annulled by national courts, and proper exporters from foreign countries got real damages.
So who would like to take that question first?
Whom do you ask a question?
Okay.
It was a question to the whole panel, because I'm interested in practice case law in all your countries.
Okay, I will reply first. So, in the case of Brazil, we lost only one case, and it was on the basis of a procedural aspect. In Brazil, all decisions must be signed by the 7 ministers that make up CAMEX, and in this case, the final decision was based on consultation and had one signature. Then we had the exporter that appealed to the court, and then it took a long period, but then there was a preliminary determination which suspended the imposition of the duty, and finally, after more than 8 years, a final determination was issued, and the duty was never imposed. So we lost this case on the basis of a procedural aspect, but that was the only case since 1995.
Well, unfortunately, I should have brought the number of how many cases, but many. We have a very active legal fraternity, and I think it's people make money through this. So I don't know whether they are so concerned with winning per se, but they like the challenge. I would say we win probably way more than we lose, especially now because of the procedures that we have. So we won't lose a case on procedure. We have lost one very big case, which was about 2 years ago, in the manner in which we calculated the 5 years that the duty stay in place. There was one clever importer that decided we were calculating it wrong. We had been doing it for 20 odd years the same way. We didn't doubt ourselves, obviously. He took us to court, and the court said, "You are counting wrong." And it was a very important case for us to lose. It had a huge effect on the way that we do our investigations. It's also one of the cases where we had to approach the court to ask for a declaratory order to explain to us, why they think we are doing it wrong. And it was it was something for us to learn. We've never had damages being awarded to us, and mostly we are very successful in the cases. I think also the people that are unhappy normally are single parties. So it's a single exporter, or maybe 2 or 3 exporters, and I think for them to convince a country to his government to take him to South Africa to WTO dispute is maybe not so easy because of the political sensitivities. So it's fairly easy to take someone to domestic court. So I think that they also do it even though damages are not awarded. But I think it's a satisfactory result and a quick result as opposed to WTO.
In our case, the benefits are quite clear. Those benefits that you mentioned, it's faster and it's less expensive, and there is a good chance that it depends on you and not on the state whether to go there or not. You can decide it on your own. You have the right to go there, while companies do not have the right to go to the WTO dispute settlement body. You need to persuade your government to do that. And with respect to damages, our system does not provide for such a possibility. The court could decide whether the decision is in compliance with the treaty or not, but it could not give any recommendations or decision on the paying of compensation or something like this.
See, as I mentioned, in our case, we have a special tribunal, and the orders of the tribunal can be challenged in the Supreme Court. So if the tribunal stays the imposition of duty, and the Supreme Court overturns that judgment, then the applicant has to pay the duty right from the date of the order. So the damages in terms of the Supreme Court order would be that while the tribunal had stayed the order and you were not paying the duty, but the Supreme Court overturns that and you have to pay the duty from day one. So the restoration of the duty is the power that the Supreme Court provides. Thanks.
In our practice, for the number, I mentioned that there's 5 cases of administrative reconsideration and 1 case of administrative suit. And for the WTO dispute, I think quite similar, 5 or, I don't remember the exact name, the exact number, 5 or 4 cases against the Chinese trade, trade remedy. And a company or interest party choose which one to go. I think it's dependent on the different situation. For the WTO dispute settlements, only a country can bring the case. But for the judicial review, any company, if their interest is affected, they can bring that to the court. But for the dispute settlement, only a member, a country can bring that to the WTO dispute settlements. So, and also the result is different. So it's dependent on different situation and depend on how the company want to get. Thank you.
Just maybe one comment whether which system concern which system to choose. To remind, there is a dispute, WTO dispute against the Russian Federation pending right now on anti-dumping duties on light commercial vehicles, and there is a WTO dispute. And at the same time, Volkswagen tried to claim to the court at the time of the Eurasian Economic Community, actually challenging the same measure. So why not proceed both ways? Well, for producers. And my question is to Mr. Human. As a WTO official, you are aware of maybe all possible systems of review. And in your opinion, are the systems of judicial review of BRICS countries efficient enough? If you compare them to maybe to the US system, or maybe to just to a average level of the world review system in different countries. And a more specific question is, what do you think about groups of experts which have been introduced in the Eurasian Economic Union for these specific reviews? Do you think it's a good thing, or do you think it will make the system more complicated, whether it can be more efficient or not? Just your opinion as an expert. Thank you.
Yes, on your last question first, I was thinking of making the comment when I think somebody said that there is a problem in domestic courts of law that a judge might not be necessarily an expert on trade remedies. Now, of course, the legal fraternity and judges would argue, but that's not new to them. They have to judge cases, highly complex cases, in which they're not experts. So what is the difference between an anti-dumping case or trade remedy case and another complicated case? Now, experience is that the world of anti-dumping is somewhat different, and it's critically important to have judges that are well informed and understand the dynamics and the whole rationale behind anti-dumping. A colleague of mine in the Secretariat, Muslim Yilmaz, published a book on 15 years of experience with judicial review. And the line throughout is that there is a concern that judges don't have the required understanding, leave alone the technical knowledge. So on that score, personally, I think it's good to have some sort of a safety net. On the question on but how it works in practice, it all depends on how you select the experts and the role of the experts, because it's sometimes very difficult for judges to take advice from outside on board. On the issue of judicial review, whether it works well in the BRICS countries, I cannot pass judgment on the members. That's not for the Secretariat. But I think the initial idea way back, as a negotiator way back, the whole idea was to have a filter process, that at least you should have an independent body looking into the issues rather than running to the WTO. What we see in the WTO is that all of a sudden, well, not all of a sudden, it's developed over a number of years, you find that although a dispute in the WTO is between governments, you see increasingly private private practitioners almost dominating the process. We have, and don't quote me on this one, but it has happened a couple of times that members are in dispute and not a single official of either party to the dispute in the room, only private sector lawyers. Now, there's nothing wrong with it, they make good money out of it. But it just gives you an indication of how things have evolved. And also, many times, governments come under severe pressure from big companies with very deep pockets. So they can bankroll the whole process. The government said, well, sorry, we don't have the resources, but if you can find lawyers and if you pay the lawyers, be my guest. Now, what you then find is a further complication sometimes, that the private sector lawyers, and not only private sector lawyers, government lawyers as well, they argue a certain point before panel or the appellate body. But the point that they're arguing in a particular case is diametrically opposed to the practice of that particular country. Or it might be that in different cases they argue different positions because they have different clients and different lawyers, which from a systemic point of view, it makes it a little bit complicated if you look at the nature of dispute settlement in the WTO. Now, a question that I have for the colleagues is increasingly, the last couple of years, I hear the comment that it's not possible to challenge a particular measure or a particular methodology or a part of investigation in a domestic court of law because of the nature of the administrative law principles in that country. So I cannot challenge the way how you've conducted your investigation in your domestic court of law. However, I can challenge that in the WTO. And the question is whether some of you have had that experience, because that's also quite a delicate question if you look at the sovereignty of the members. So I cannot challenge in domestic court of law, but I can undermine your own domestic legal system by challenging it internationally.
Any more questions? Okay, it doesn't seem to be the case. So thank you for all the presenters and all the questions. I think our session has completed. I will hand you back, Mr. Ilichev, the floor.
Thank you. Looks like we have done with today's. Thank you, everybody, for participation in this event. We are really glad that we had such an opportunity to exchange our views on that. Hope that you find it helpful. And I wish you a good evening and good time in St. Petersburg.
Thank you very much.
Thank you.
Thank you very much.